The court calls the matter of Hale versus Hale, case number 2014-6005 DM. All parties and attorneys could please state their name and appearance for the record, starting with plaintiff's attorney, Ms. Kirkpatrick.
Good morning, Your Honor. My name is Nancy Kirkpatrick and I represent Jessica Crouch, and she's here to my right. Would you please state your name for the record?
Jessica Crouch.
Good morning, Your Honor. Attorney David Moore for Kenneth Hale. Kenneth Hale is present. He's sitting to my left. Please. Kenneth Hale.
Good morning, everyone. Today's date and time set for hearing for an objection to a child support order. The decisions of the Supreme Court and Chief Judge have made these hearings done by remote technology. The contents of this video may be the official record of the proceeding of the State of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, alteration of said content is strictly prohibited. Today's date and time set for hearing. Mr. Patrick, you filed an objection to the child support order, and I don't know if it was a hearing or a consent agreement. You're on the record for about 28 minutes, according to my staff with referee Leo. But you have two claims. One, that the amount for medical insurance was mistaken, and that there's a difference now in what the plaintiff is paying for child support. Is that correct?
Yes, Your Honor.
Okay. Mr.
Not child
Moore,
support, but child care.
Child care, yes, I'm sorry. Mr. Moore, any position on those two matters?
Well, Your Honor, what procedurally what happened, the parties had mediation December 11th of 2020. In that mediation, parties agreed to all issues as far as custody, and the parties agreed that there would be no child support paid by either side. An order was signed, I believe, in late December of that year, and then a few weeks later, with no change in circumstances, the plaintiff then requested for child support. We protested at this earlier hearing this year, said, no, there's been no change in circumstances. The parties had an agreement. The referee proceeded, added up the amounts, and lo and behold, the plaintiff now has to pay around $50 a month. We've objected all along because we believe the parties had an agreement, and there's been no change in circumstances. The information that my client gave at the referee hearing earlier this year was accurate. He gets insurance through his wife's company, and as a result, there's a payment of $450 a month. The information that my client gave is accurate. I object to plaintiff's original motion, and I object to plaintiff's subsequent protest of the order.
Okay, I am not aware of the history. I'll look into that. Ms. Kirkpatrick, is that history correct, that we keep coming back for more bites at the apple, or were things, I guess, where's the misunderstanding with the prior hearing with the referee?
There isn't a misunderstanding, in my opinion. We did mediate the matter of the defendant's change of custody and parenting time motion, and we did, and we reached an agreement that went into an order dated January 4th, 2021. But it isn't a matter of we said there would not be any child support. We indicated that there wouldn't be any until further order of the court. And I remember specifically indicating that we needed to discuss that issue, and in order to not affect our custody and parenting time settlement, I was just going to put it off and address it separately later on, which is what I indicated to referee Leo. And we then went forward on it at that point. But father indicated, you know, that he, at the hearing with referee Leo, he earned so much money and he was paying so much in medical expense. And now check stubs that I have for him do not indicate that he is paying that medical expense. And the fact that now I hear today that his wife is paying it, not him, which is why it doesn't indicate it in his checks. But that is not the same thing as testifying that he is having $450 a month taken out of his paychecks.
Okay. All right, so I guess we'll set this matter for a hearing. I am looking at the order signed back in January 2021 by referee Procunior, and it says that there will be no child support ordered until further order of this court. So I do think it's an open issue. Let's get the pay stubs exchanged if necessary, and any child care bills. I'm going to want to know the history of child care and why, if all of a sudden it's $50 every 2 weeks, where that came from. But I'll set it for a hearing. Do you folks think 2 hours will be enough?
Yes,
Yeah.
sir.
Okay. Encourage the parties to work with their attorneys if there's some sort of agreement that can be reached on any issues that lessens docket time, but if not, we'll get you 2 hours. We'll go off the record. Everyone sit tight. All prior orders remain in effect until we get this satisfied. It's not Ms. Kirkpatrick's fault. It's an oddly worded title. It's an objection to child support order, but it's also from the referee. So the court will be looking at everything now and with regards to child support, and I'm not sure what the court will do. We'll have to wait till all the proofs come in. Any questions by any parties?
No, sir.
No, Your Honor, thank you.
Okay.